There you
Good.
Il y a l'usage, un ancien CEO, puis avocat.
Ready to go.
Okay.
Il était CEO
So we dealt with
Bedford,
direct,
London.
indirect, and deemed conflicts. Now we're going to deal with the exceptions. So Section 4 in the Municipal Conflict of Interest Act is where you go to find the exceptions. And I've handed out a card in these folders that sort of takes you through the decision tree process. So this is designed to have with you in your council agenda. So it takes you through the process. So the first thing you check is if there's a pecuniary interest, and then you see if it's a direct pecuniary interest. That's easy to tell. That's if you have an interest in it. Is it deemed? So does it affect your parent, spouse, or child? Is it indirect? So it's the shareholders, the member of a body, or your employer. And so if you answer yes to any of the, if you answer no to all these, you don't have a conflict and you're good to go. If you answer yes to any of these, then we get into the exemptions. So I've given you a link to the exemptions on e-laws because the card would be like this long to get all the exemptions on there. But what's important on here is that, again, it's not a bad thing to have a conflict. It's a bad thing to not declare a conflict and to have the Integrity Commissioner's email so you can ask for advice if you need it. So that's what that card's for. So the exemptions, here we go. They start easy. So you have an exception if you are a user of a public utility service supplied to the councillor by the municipality or local board in a like manner and subject to the like conditions that are applicable in the case of persons who are not members. In other words, if the councillor is a customer of a public utility just like everybody else in the municipality, you have an exception so you don't have to declare a conflict. So I understand that you have a telecom system in town. So just because you're a customer of the telecom system doesn't mean you have a conflict you have to declare. That's just the customer though, because we're going to get to what happens when you're on the board, because that's different. So the first one deals with a public utility. If you're a customer of a public utility, just like everybody else, you're fine. Next is, by reason of the member being entitled to receive on terms common to other persons any service or commodity offered by the municipality. So what this means is if the municipality picks up your garbage, just like everybody else's garbage, you don't have a conflict as it relates to garbage pickup in the municipality. Because without this exception, arguably, you're receiving a benefit from the municipality, so you would have a conflict. So if you're receiving a service from the municipality that's the same as everybody else, this exception would apply. Okay? Next one is if you're the owner of a debenture, so you bought a debenture because you're funding a water plant or an arena or a pool. If you have a debenture, this exception applies because otherwise you have an interest, a financial interest in the municipality. So arguably you've got a pecuniary interest in all of the financial interests of the municipality. So the debenture is an exception. Next is if you've made a deposit with the municipality. So I think this is probably most often used in tax accounts. So sometimes people prepay towards their municipal taxes. So this says if you have a deposit with the municipality, then in a like manner as anybody else, then this exception would get you out of declaring a conflict. The next section deals with the Drainage Act. So what this means is that if your property is benefited by a municipal drain, and I mean a municipal drain under the Drainage Act, not just happens to be a municipal sewer catch basin on your property, but a Drainage Act drain, or your property has a Drainage Act drain on it, you're accepted from that conflict. Next one is if you own or have an interest in farmland that's exempt from taxation, there's an exception to cover you. So then these two get into when you're on a board. So the first is by reason of the member being eligible for election or appointment to fill a vacancy, office, or position in the council or local board, when the council or local board is empowered or required by any general or special act to fill such vacancy, office, or position. So where council has to appoint people to the DSAB as an example, if you get appointed to the DSAB, this exception would say that you can come to council and participate in decisions about paying the DSAB's bill. I guess there's not much to decide there. They send you a bill, you pay it. But if you were involved in anything about the DSAB, this exception would cover you. And the next one similarly deals with when you're appointed to a local board, commission, or other body. See, we're using the broad language again. So that would be any committee that you get appointed to as a councillor. It would be your local boards, like your public libraries board, your police services board, things like that. So this would exempt you from coming to council to talk about the interests of that board. Now, it's important at this point to pause to understand that these exceptions are specific to the language within the exception. What I mean by that is this would accept you from a conflict because where your conflict is because you're a member of a body. So if you're on the museum board, as an example, and your only conflict is because you're on the museum board, then this exception would apply. But if you have another layer of a conflict, like your spouse works for the museum or you sell services to the museum, then this exception would not cover that. So these exceptions only apply to the language in them. So they only apply to the fact that you're appointed to the board. The other thing that we've seen is that some members of council are sitting on boards as lay people. What I mean is council doesn't appoint them to that position. So we had a councilor who sat on a library, it was a museum board. And the council doesn't appoint people to that museum board, but a guy who was a councilor happens to sit on the museum board. So this exception would not apply to that situation because he's not appointed to the board by council. So this exception doesn't get you out of trouble on all of the boards that you sit on, but only the ones that you sit on because council said you have to sit there. Is that clear?
Okay, what about people from the general public that are on boards, on local boards?
Right. So
we're talking over here. We're talking about councillors that have been appointed to these boards, but you also have member of the public on the boards.
That's a good question. So the Municipal Conflict of Interest Act generally applies to those boards. There are some boards that are excepted from that, but it generally applies to the local boards, and so the Conflict of Interest Act would apply to them as they sit on that board. In other words, if that board is considering something where they have a pecuniary interest in it, then they have a conflict, and the Municipal Conflict of Interest Act would apply.
Okay.
So even though they're not councillors, they're still caught by that if they're members of a local board.
So they go under the same rules and regulations.
That's right.
Okay.
That's right. So for instance, if you were a lay person appointed to the DSAB or from the unincorporated areas appointed to the DSAB, the Municipal Conflict of Interest Act still applies.
Okay.
Clear? Mm-hmm. So this gets you out of coming to council to report about the boards that you're on. So paragraph I is important for members to understand. This is interesting. This accepts you from dealing with, or permits you to deal with, honorariums, remuneration as a councillor, remuneration as a member of a board. And so it talks about allowance, honorarium, or remuneration. So that considers your council stipend. But it also talks about salary or benefit. and I had a mayor that was involved in an election challenge, and he was one of the respondents in the election challenge because the challenger was challenging the mayoral race, and so he had to retain his own counsel and participate in that process. And he, because of this this exception with the benefit, because he was participating in the litigation as the mayor, he was able to go to council and say, "Council, would you repay my legal expenses because I was defending the election, essentially?" And so he was able to get an opinion that this benefit word includes other financial benefits that you might be entitled to as a councillor. So this exception allows you to come to council to say, "Hey, council, will you cover my expenses for litigation? Hey, council, would you cover my expenses to go to Phenom or Aroma or stuff like that?" That's where this exception comes in. Any questions on that? Okay. So the next two are the tough ones, and I want you to be careful with them. So paragraph J is, because the member has a pecuniary interest, which is an interest in common with electors generally. Now, this doesn't say an interest in common with all electors in the municipality. And the courts have determined that this can mean a subset of the electors in the municipality. So councillors have been successful in using this section in saying that they're exempted from a conflict because they're voting on paving their road, because the pavement of their road would improve the value of their property, but also all the rest of their neighbors on the street. So the courts have said that that's an interest in common with electors generally, even though it's not all of the electors in the municipality. It's also been used for things like a cottage owners association, where the councillor is a member of the cottage owners association, but has the same interest as all of the cottage owners. So was able to come to council to say that council should do something. I think it was a boat launch case, to put in a boat launch to benefit the cottage owners association. And the court said that that was an interest in common with electors generally. They've also, well, it's more the next one. So I've had a councillor unsuccessfully argue, how did it work exactly? She was suing the municipality. She was saying that various policies and procedures weren't being followed, and that she should be able to sit in a council meeting where council was discussing her lawsuit, because what she's doing is in the best interest of the municipal ratepayers, she said. Ironically, she was the one that was claiming damages, and she didn't suggest in the claim that she was going to share it with all of the ratepayers. But we said that having an interest in common with electors generally is not the same as doing something that you think is in the best interest of the ratepayers. So in other words, if you own a business and that business somehow benefits the municipality, or many of the ratepayers in the municipality, that wouldn't be the same as saying that you have an interest in common with the electors in general. It has typically been used for in geographic areas. That's where it's been used successfully. Like I say, the paving of the roads and the cottage owners association are cases that it's been successful. If you think that this is your exception, I would urge you to talk to the integrity commissioner before you take advantage of it, and get the integrity commissioner to agree with you that that exception would apply. And that way, if at the end of the day a judge says that you're wrong, well, you've been careful, you got the integrity commissioner to bless it, and so I would suggest that. Paragraph K is almost impossible to predict. So what this says is that you don't have a conflict if it's by reason only of an interest of the member which is so remote or insignificant in its nature that it cannot reasonably be regarded as likely to influence the member. So this is the remoteness, or what we call de minimis aspect. And so when I read this, I think that it sort of suggests that if the money is small enough that it wouldn't really matter, that the councillors accepted, and the courts have said that that's wrong. There was a case where a mayor and 2 councillors were members of the local Chamber of Commerce. And the mayor had a business membership, and the 2 councillors had what they called social memberships in the chamber. The mayor was a business owner. And the complaint was that the councillors were sitting on a request from the Chamber of Commerce for a donation. So the municipality was going to donate money to the Chamber of Commerce, and the chamber was going to use that money to publish a business directory. And the court said that publishing the name of the mayor's business in the business directory was sufficient to be a conflict. It was a sufficient pecuniary interest to be a conflict. In other words, it wasn't seen as so remote that it could not reasonably affect the or influence the member. Now, I don't know how you would measure the financial impact on the mayor's business there. So I don't know how the court would say that just publishing the guy's business name, actually it was a woman's business name, in the agenda, or sorry, in the directory would be a conflict. So I want you to know that, because to me that seemed pretty small, and I thought that would fly, and the court said no. Where we have seen that work is in cases where the pecuniary interest hasn't what we call crystallized yet. And the example is a case where a councillor, so to back up, the council was interested in buying property. And the property was owned by a company that was a defendant in litigation. One of the councillors was a plaintiff in that litigation. But the vendor of the property wasn't the only defendant. So it was litigation by multiple plaintiffs against a whole bunch of defendants. Now, what we said was that that was too remote, because in order for the councillor to actually have a financial interest in the defendant, he would first need to be successful in the trial and get a judgment. He would then have to be unable to collect the judgment from any of the other defendants. And then the real estate transaction would have to essentially frustrate the councillor's ability to get money from that one defendant. So there were so many contingencies that would have to happen before the councillor actually had a financial interest in what was going on with that defendant, that we said it was too remote. So that's an example where, there's really the pecuniary interest doesn't really exist yet, because there's no monetary interest at the time of the vote. So that's where that has been successful. Any questions on those? Too much sugar pie. So what I want you to understand is that where you're using an exception, particularly where you're using the last two, it's a good idea to get advice from the Integrity Commission. So we'll talk about the process now. And this is why this is such a big change. Before March 1st of 2019, if somebody was upset at a councillor or a member of a local board for breaching the Conflict of Interest Act, they actually had to sue them in the Superior Court. And if you've ever been involved in litigation in the Superior Court, you know that to sue somebody costs at least $10,000. And so what that meant is not very many ratepayers did it. Well, after March 1st, they broadened who could apply under the Municipal Conflict of Interest Act. So it can now be anybody purportedly acting in the best interests of the municipality. So it doesn't have to be a ratepayer. It could be a person over in China who has been watching your council meetings and decides that they want to make a complaint. It could be anybody in the world now. And the suggestion that it's qualified by the idea that they're purportedly acting in the best interest of the municipality. I mean, the Act says it's in the best interest of all municipalities for councillors not to act in a conflict. So anybody making a complaint is going to be seen to be acting in the best interest of the municipality. The complaint process now goes to the Integrity Commissioner and is free. So people can make a complaint whenever they know about a breach of the Act. So the $10,000 cost is gone for the person making the complaint, and now it's borne by the municipality. So after March 1st, the complaints are free. Complaints are made to the Integrity Commissioner. There are some parameters on the complaint. So the complaint has to be made within 6 weeks after the person learns of the breach. Not 6 weeks after the breach happens, but 6 weeks after they learn about it. There's also a 6-year limitation period.
It's kind of broad, isn't it?
Well, 6 weeks is pretty short.
6 weeks of,
Oh,
since the day he knows about it.
that's right.
You could know about it 2 years down the line.
That's right. And the limitation period on it is 6 years. So the interesting thing about this legislative change is it actually goes back 2 terms of council.
Yeah.
Because if somebody, as for instance, you know, you as a brand new councillor may be reading through the minutes and say, holy smokes, Councillor so-and-so 2 terms ago, but within 6 years, had an interest in this issue and he didn't declare it. So you can make a complaint to the Integrity Commissioner because you just found out about it and the Integrity Commissioner would have to investigate it. So even old councils are now subject to this new regime.
So don't make that presentation to the public. We all want to go to jail.
Well, it's interesting that you say that because one of the questions I got yesterday was, when should we tell the public about this? Our job is not necessarily to tell the public about this. I've been telling councils, let's educate council first, because this legislative change has been made by the province and everybody's deemed to know all of the laws that they pass. So we don't have to educate the public, but there may be a time where council decides that they want to do that, and the Integrity Commissioner can do that with you or for you if you need to. And I can see that it is something that councils may want to do, particularly in small municipalities where you're related to lots of people, and you know that the deemed conflict is parent, spouse, or child, but the general ratepayers think that it should also include brothers and sisters and cousins and best friends. So you may want the Integrity Commissioner to come and do a bit of a public education session to say, okay, stop making complaints because this is not a conflict. You might not like it, but that's what the legislature has said. Okay, so after March 1st, the complaints are free. They're investigated by the Integrity Commissioner. The person making the complaint has to swear an affidavit saying, I only learned about it within the last 6 weeks. And that, I think, is something that the Integrity Commissioner will examine a bit. And then, actually, did you have a case that they came to you after 6 weeks?
Yes.
Well, tell me about that. What happened?
So the complainant made a number of code of conduct complaints as well as conflict of interest complaint. And when I asked him when he found out about it, because he had made the complaint directly to me, hadn't gone through the process with the municipality, I asked him the question as to when he found out about it, and he said 2 years ago. So I knew right then and there it was not something I could investigate, or I would have told him to go back to the municipality and sign a declaration form.
So it is a hard line. If they learn of it more than 6 weeks, then the Integrity Commissioner no longer has jurisdiction to deal with that.
So I got a question.
Yeah.
So you might tell me no, but I won't answer. But because we're live streaming on Facebook, we're not only letting people of Hearst know what we're doing, the world has access to every meeting. And any Joe Schmo can look at this and try to do it.
Yeah.
So it'd be a good idea for us to put it on a local channel than rather to give anybody.
Well, it's a better
Check it out.
idea. It's a better idea not to breach the act.
I can't control like
Yeah,
anybody.
you're right. You can't control what anybody says, and the
I don't know
the
who his
people. Yeah.
brothers and sisters or
Yeah.
kids are. I don't know everybody personally, right?
Yeah.
But I'm involved in it.
And the reality for council is that the complaint process and the investigation by the integrity commissioner costs the municipality money. So you don't want to see unnecessary complaints. I mean,
Somebody that lives down the road that's
Yeah.
not even in the municipality,
You-
but hates everybody in Hearst.
Right.
It's going to try.
well, and
Yeah.
I was afraid that after March 1st, we were going to be inundated with complaints and that a ton of people were going to be making complaints. And that's not really what's happened, eh? I mean, Peggy acts for, well, her company acts for 54 municipalities. And how many conflict complaints do you have so far?
Including the one that I dismissed.
Yeah.
I have had 6, and of them, I dismissed 1, and 2 of the people have not signed declaration forms. So I'm
So
down
that'll
to,
probably go to.
so I'm down to 3 that I would be actually looking at investigating.
Okay, so that's not.
But most people don't
Insignificant.
know about these changes.
Yeah, so start.
Yeah,
I know Fred Dean was saying that in his opinion, to watch out like a year or so before the next elections, because that's when debates are going to start and people are going to try to find something wrong,
I
that
would.
to expect it more then.
Yeah, I think that's some interesting advice. What we have seen is that the complaints that Peggy has got under code of conduct have been, how many you got?
24.
24 in just a few months. Most of those have been from other counselors. And they're being used, I would say, to an extent strategically. So there are issues that are dividing council. And so counselors are complaining against each other, you know, either try to take them out or.
Spending their own money.
But that's the point I think they can't do. He's talking about Facebook, but even, I take myself as an example. When I'm done in politics, I know that's on.
Yeah.
I know where to go if I want to make a complaint, because I know what it's all about. If I want to make give problem to council, the next council, I could go and make some complaint and watch it closely, or don't give them a little,
No matter where he is.
yeah.
So definitely something for you to look forward, think about, and see,
look forward to.
And what
and see
about-
how it's working.
And what about the public making a complaint on an issue? Okay, the mayor don't talk, didn't say the right thing on the media, and he was quite rude or.
It's not the same.
Is that
Well,
the same?
it can be a code of conduct complaint. I mean,
Okay.
that's where you get into civility and proper conduct. So if you're cursing and swearing on the media, probably somebody's going to make a complaint, and then that would be investigated by the integrity commissioner. So that might happen. So under the Conflict of Interest Act, once the complaint is made and the proper declaration is signed, it has to be investigated by the Integrity Commissioner. We've come up with an Integrity Commissioner protocol. It's like a policy that the council sets about how the Integrity Commissioner does their work. And what we say is that the very first thing the Integrity Commissioner does is an initial review to determine whether the complaint is appropriate or whether it might be a frivolous complaint. We're doing this because we've seen other municipalities where they don't say that, which means that the Integrity Commissioner has to do the full-blown investigation before they turn off the tap. So this is a way that you can hopefully save some money. And have you tossed anything on initial review yet?
3.
3, okay. So it is saving municipalities money to do that. Now, Here's why it matters
Saves
to
me work, more important.
here's why it matters to you. So if the integrity commissioner gets a complaint and finds that you've breached the act, then they're encouraged by the legislation to actually take you to the Superior Court, because it's the judge of the Superior Court that has the ability to issue the penalties. The judge of the Superior Court, if they find that you've breached the act, they can vacate your seat. They can order that you not run in another election for up to 7 years. They can issue a reprimand. They can order you to pay back any benefit that you've received. But the thing that's really going to hurt, I think, is in the Superior Court, the unsuccessful party generally pays the costs of the successful party. And to give you an idea of the magnitude of that, I was involved in an action with a ratepayer, and just last week I got a cost award against a ratepayer who was one of these frivolous complainers for $34,700 on one motion. So the costs on the whole action would be more than $100,000. So if you are a councillor who loses in court, the cost award, I think, is going to be a substantial financial hit. Plus, you would be required to retain your own legal counsel or represent yourself. The Municipal Act actually prohibits municipalities from buying insurance that would cover the expenses of a councillor if they're found to have breached the act. The flip side of that is that municipality could buy insurance or could cover the expenses of a councillor if they're found not to have breached the act. But they have to be found not guilty before you can pay their expenses. So that's actually something that you may want to look at with your current insurance to find out whether they have legal expense coverage, to find out whether they will cover you in a Municipal Conflict of Interest Act complaint, and also to find out whether they're covering you in case you're found guilty. I don't know if that coverage exists, but if it does, you're paying too high a premium because after you're found guilty, the insurance company is not permitted to pay those expenses under the Municipal Conflict of Interest Act. So it's a good idea to talk to your insurance provider and get your broker to just clarify the coverage to see whether there is any and whether it's designed to comply with the Municipal Act. The Municipal Conflict of Interest Act.
What you're saying is welcome to politics.
What I'm saying
Bring your
is
wallet.
be super careful about the Municipal Conflict of Interest Act, for sure. And advice is way cheaper than litigation.
So before you go on, Paul, one of the things that I want to say about that as well, when you're talking to your insurer, you may want to ask the question. So if the integrity complaint goes to the integrity commissioner, and the integrity commissioner says that there was no breach of the act, and the person who's made the complaint is not satisfied with the integrity commissioner's report and decides to sue the member of council, and the member of council is shown not to have breached the act, if the insurer would cover that as well.
That's a good point, because the integrity commissioner is encouraged by the legislation to prosecute you in Superior Court if they find a breach, but they don't have to. And if they decide not to prosecute you, then they have to publish written reasons why they're not going to do that. So I told you about the case of my my counselor who was separated from the woman for 40 years that the judge threw out. That's the kind of thing that the integrity commissioner might say, yeah, it's technically a breach, but I'm not going to take them to court because there's no way the guy could have known that he was in conflict. So I presume, I mean, I don't mean to put words in your mouth, but I would expect you'd probably turf that.
I'm not going to waste taxpayers' money to take somebody to court if
They
With
try
this-
to comply.
if there was an attempt to comply with the legislation. Where I can see an integrity commissioner actually taking a counselor to court is if you don't tell them the whole story. That's gonna be the first critical piece, because if you told me that it was your cousin and I gave you advice, and I get a complaint and I now found out that your you're married to your cousin, then I'm going to take you to court. Because that is not an acceptable behavior for a whole number of reasons.
In the church.
Wasn't thinking that one. But for the most part, I mean, council is here to make really good decisions for the community. And in order to do that, you need to be following the legislation the best that you can. And like Paul says, if you have any kind of questions, reach out.
Best if you can, I mean, we all volunteer to be in politics, and you know, best if we can. It's not perfect.
That's
We're gonna make some mistakes,
Absolutely.
and those mistakes should be at risk all the time. So I think in the future we have to say to the people who wants to really get involved in politics, be careful.
So let me tell you,
So it's going to be really scary for the people who wants to join politics.
you know who I think it's going to be scary for? Not the new people, because the new people are going to grow up in this regime. The ones I'm scared for are the ones that have been on council a whole bunch of years, and nobody's ever, like my counselor that came to me and said, well, I've always come and asked for the donation for the Legion, and I'm a Legion member. You've always breached the Municipal Conflict of Interest Act. It's just that nobody's ever taken a run at you because nobody was offended by it. But once somebody starts realizing, hey, this is free and it's going to cost the municipality tens of thousands of dollars, so if I want to stir up trouble, I can make this free complaint. That's when the experienced councillors are, I think, more at risk.
Thank you very much. I'm going to speak well.
And I'm going to give you a different example, because a lot of it, you know, we think about that complainants are going to be frivolous or vexatious. That's not always the case. I have seen councils where there's been a member of council who sat at the table who owned a gravel pit. And every time that the RFP was passed at the council level, he voted on it. And every time that the RFP came in, he had the bid that was successful. So there were other bids. It wasn't like he was the only one, but he voted on it and he was part of the decision making. And this is what this will prevent, because the community members weren't going to hold him accountable. Now there is that recourse.
That's a good point. So, as I said, I've been practicing for 22 years, and I've probably been involved in about 4 municipal conflict of interest litigation files. So that's not very many. I've probably had 12 more where people have come to me saying, you know, this is a conflict and I want to take the person to court. And then when you start talking about the costs, they say, well, let me see if I can get a bunch of people together and we'll fund it. And it falls through.
Troublemaker.
So, well, troublemaker or not. No, not always. Sometimes they were actually legitimate complaints, I think, and I thought that they had a good case. But regardless of whether they got a good case or not, it's going to cost them tens of thousands of dollars to go and be right. And so lots of people didn't take the step of taking counselors to court. And those ones who got away with it, often probably not intentionally, more likely that they just weren't thinking about it or what have you. They got away with it a number of times. Now they think it's okay. And those are the ones that I worry are going to be made examples of. So we're just about done this part. Investigations, I need to update these numbers on both ends. Investigations that we've been involved with, the cheapest one now is
I'm down to $1,500.
$1,500. That, I don't know how you did for that. And the most expensive one that I've been involved with now is over $200,000. That involved a police force and multiple levels of problems, but they're a significant hit to your budget. It is something that I would urge you to be finding out about insurance coverage for and setting aside reserve funds to pay for investigations, because I bet you're going to have at least one investigation, if not more than that, during this term of council. So it is the kind of thing that you want to set some money aside for. litigation is going to increase the cost. So those are just the investigations. That's not the litigation layer on top of that. And so I think it's appropriate to budget for it. What it means for counselors is that before you participate in any issue, think about whether you have a conflict. Look at the card. It's not a bad thing to have a conflict, but just declare it if you have it. Remember, when you have a conflict, you're prohibited from influencing the decision before, during, or after the meeting. So don't talk to counselors about it at the coffee shop. Don't sit in the meeting and shake your fists, and don't wait out in the parking lot and swear at people after they have made the decision. And I wondered initially when I read it, I thought, why would they say after? Because once it's done, right? But the after is because council can, and some of our clients make a big habit of reconsidering decisions. So you could wait in the parking lot after, and then council come back in the next meeting and reconsider it and go your way. So that's why they've said you're not allowed to influence the decision at all. Get advice, tell the commissioner.
Before you go on, Paul, one of the things that I'm trying to remember happened not too many trainings ago, someone asked whether or not if they declared a conflict in a closed session, whether or not they could know the result of the decision.
And what's the answer?
No,
Good point. Okay, so
that was your answer then.
it was.
Well, they'd find out anyways, if it's a
Not
vote.
But they
not
don't.
this closed session necessarily.
So this is important for you on the minutes. If somebody declares a conflict in the closed session, when you're circulating the closed minutes for approval, those minutes don't go to the counselor that declared the conflict. You have to make sure of that. That's something that
It'd be the same, like, let's say if somebody, I don't mean to point the finger, but let's say the CAO's performance was being discussed, I wouldn't distribute the minutes in the council package to him if it
Right.
pertains to him
right.
or to someone.
Right. Now, he's not
He
subject to the
needs
Municipal
know
Conflict
his
of Interest
performance.
Act.
No, but it's just
yeah.
the way of thinking.
That's
that
right.
It's just common sense,
But-
really.
But I think a lot of clerks routinely circulated the minutes in the closed minutes for approval to all of council.
Yeah.
And so you need to be diligent to be careful if somebody has declared a conflict that you don't put them in a position where they're now getting access to that information. And now, at the end of the day, if the decision is made public after the closed meeting, well, they're going to know just like anybody else.
No, that's what I meant. They're
But
gonna
really,
find out anyways.
it's the minutes, and sometimes you don't. Sometimes the decision doesn't become public, right? So if you give direction to
Yeah.
staff or you give direction to legal counsel in closed session to take certain action, that might not be made public in the open session, right?
But that'd be
You're-
hard to keep secret though,
Well,
because
well, I'm gonna go back and use the example that Paul gave about the member of council who was litigating against the municipality. So in that situation, the litigation and the direction to the lawyer is done in closed session.
Mhm.
And it won't come out in open session for a very long time. And if it does, members of council have breached their code of conduct.
And all
And
that
it's-
comes out in public was that in closed, we gave
Discuss.
direction to legal counsel.
Yeah.
Not what it was,
Not
right?
what it was.
What it
The
was, yeah.
direction is
Yeah.
kept confidential until such a time as council releases that decision.
So one of the things that municipalities are concerned about, and I think rightfully so, is what about false complaints? So in our integrity commissioner protocol, what we've said is that if the integrity commissioner finds that the complaint is vexatious, then the municipality can take action against the person that made the complaint to get their costs back. Now, vexatious is a higher level than saying that the complaint is not substantiated. So lots of times somebody will make a complaint and say so-and-so breached the act or they breached the code of conduct. The integrity commissioner will look at it and say, no, it's not really a breach. If it was a good faith complaint, that's not a vexatious complaint. So it doesn't have to be proven right to be vexatious. But where where I've designed this for is the municipalities where they have their frequent flyers, as they call them, where they're just making complaint after complaint after complaint, and the municipality is spending money on the integrity commissioner dealing with garbage complaints that aren't true, or worse, they're made up, and the person making the complaint knows that they're not true. Those are the people that council would take the decision to go after. The policy or the protocol permits council to make that decision. It doesn't mandate it. So you don't have to go after somebody because the integrity commissioner said that they made a vexatious complaint, but it gives you the ability to do that. It would be a decision of council and a political decision about whether you want to take that step. But where you're spending potentially tens of thousands of dollars on it, especially if it's a repeat customer, you may want to do that.
Who would call it vexatious? Would it be the integrity commissioner? Yeah.
It would be the integrity commissioner. And tell us about what you look at for a complaint to be vexatious.
I would say if I had to sum it up into something, if it's malicious. There's been a couple of examples that I can cite primarily from the workplace harassment side of investigations that I've done, because we haven't done a whole lot in terms of the integrity commissioner side yet. But when it came to those kind of complaints, it was typically someone who was making allegations that were partially true but not totally true, and substantially elaborating them to make somebody else look bad. And to the point where they were maligning the character of the person outside of even just the complaint. They were, it was quite significant, that one.
They're using it as a weapon,
That
is what I'm thinking of, if I'm thinking of the ones you're talking about.
Yes, absolutely. And the other time I could see where I would say a complaint is vexatious is if there's a couple different ways. So the chronic complainer who's coming and making complaint after complaint after complaint about one person, just because they don't like this person and the person can't blink and they make a complaint. That I could see becoming a vexatious complaint at some level. You have to be careful because, you know, it's about the little boy who cried wolf. You have to be careful that you ensure that you do your due diligence to make sure that it is a vexatious complaint. The other time I can see is when you have a group of people. Complainant one makes a complaint and I already make findings. Complainant two makes the same complaint and I make, you know, you have a group of people that do this.
Yeah.
So you're being they're manipulating.
That's the word.
They're manipulating the integrity commissioner
Yes.
process.
But
Yes.
to a point there, I got a hard time to understand. You're in council roundtable and you don't agree with one of the councillor, or I step down and try to make my argument, and he could turn around and say, okay, you're attacking me personally, or so how much room we've got to debate something?
That's an interesting question. So we actually discussed this in another municipality, and they decided that their integrity commissioner is not going to investigate complaints about behavior during meetings, because that's the head of council's role to make those decisions. And the integrity commissioner is not sitting in appeal of the head of council. So what they've said is, if somebody is misbehaving at the meeting, that's the head of council's responsibility to direct them to behave properly, and then to, if necessary, eject them from the meeting. So it's your control in the meeting. It's integrity commissioner outside of the meeting. Does that answer your question?
Yeah, I mean, it's myself going down and debate something, so it's
Yep.
Go ahead.
It would have been the acting mayor at that point.
the acting mayor's gotta make the decision. It's enough, it's enough.
That's right.
So you
That's
Next
you
time
do
I'll
your
throw-
job, okay?
Next time I'll throw you out.
Let's make a deal. No deal.
Yeah. So debate And civil debate is what we're supposed to be doing in council meetings. Disagreeing is not a breach of the code of conduct. Telling somebody you're going to effing kill them is, I think, a breach of the code of conduct. And that actually raises an interesting issue. This is a real life example. The integrity commissioner, if they receive a complaint and they're looking at something and it turns out that in fact this is a criminal offense or this is workplace harassment, then the integrity commissioner is going to say, hey, I'm going to step back and I'm going to refer this to the police, or I'm going to refer this to a workplace harassment investigator, and I'll deal with it after they have. So their, I'm not sure if you would agree with me, but their role is sort of subject to a higher authority. So if there's criminal behavior going on, they're going to send it to the police, and they're not going to interfere with the police investigation.
Exactly. I don't. You wouldn't interfere with the police investigation, but you might, after the investigation was done, use that outcome as
a baseline.
a baseline. Exactly. What you would deal with from the code of conduct side of things. It wouldn't make the code of conduct complaint go away, but it would be something that you may consider, depending on the nature or how long it takes.
You don't come on council and say you killed someone, but I mean, you could have a good debate, doesn't matter how far we could go. I mean, without saying I'm going to kill you, it's most likely you don't agree with them.
Yeah. So
this situation was a member of council. There was a debate going on, and the member of council said it to somebody who was in the audience, and it was caught on their live stream. So there's an expectation that there may be a complaint come in against this member of council. Now, the head of council didn't hear it and wasn't able to police the meeting because they were engaged in making sure the debate was being handled properly, following their procedure bylaw.
So that might end up with the police.
Yeah. Does that answer all the things that we were?
No, there's one more. I'm not quite remembering. Okay, so I think I've probably covered this, but the integrity commissioner now polices the Municipal Conflict of Interest Act, the Code of Conduct, Staff Council Relations Policy, and any other policies that the municipality passes governing the ethical behavior of members of council. So if you pass some other policy dealing with how you expect councillors to behave, for instance, you say councillors must attend training sessions or something like that, and you then say that is a requirement for councillors and we're going to have the integrity commissioner oversee that, then that's something that the integrity commissioner could look at. My point is, you can pass more policies and give the integrity commissioner control over those if they're governing the ethics of members. We've dealt with the advice, and also important to understand is that they can provide education to council and they can provide education to members of the public. So the education to council is generally going to come from a request from council, but the integrity commissioner, I understand with your relationship that E4M is going to provide an annual report to council. But one of the things that I think is also going to happen if you get multiple requests for the same piece of advice, again, the advice is confidential, but if the integrity commissioner sees that your council is struggling with a particular issue, then they may say, hey, I want to come and give you a little bit of education about what is a deemed conflict. And so there's an opportunity for the integrity commissioner as well to say to you, I think you need a bit of education on this particular issue. Can I come to your meeting for half an hour and provide that advice?
And
not advice, education.
Education. And I think that where I could see public education happening, at least at this point is I've had a number of people call me with complaints about staff and about municipal process. That's not my jurisdiction to investigate, and I've told them that they need to send a letter to council directly. So I've probably had 6 or 7 calls like that. And if that was happening consistently in the community, I would encourage council to do something to stop these people from sending complaints that are coming wrongly to me and should go through a different process in the municipality. Which means council may put out a newsletter. It doesn't have to be somebody standing up here and talking. It could just be something simple like that.
I mentioned this briefly, but it's important to understand that the requests for advice have to be in writing. That's actually under the Act. So the Integrity Commissioner doesn't have any ability to say, but not in this case or not for you. And we've had a number of situations where councillors immediately before the meeting want advice, and they're trying to phone the Integrity Commissioner. And the Integrity Commissioner is going to say, I can't provide the advice to you over the telephone. And that's largely because of that Section 9 section that says that the judge is going to look at whether you got advice. Because if it's over the telephone, then there's no evidence about what happened there. With respect to advice, we've talked about the process being confidential, but council is in charge of deciding how the advice is going to be funded. In other words, you decide what are the parameters around advice. What I've seen 3 or 4 different ways to do it. It seems that most municipalities are saying, let's see what happens for the first year. So they're not putting any parameters on advice, hoping that councillors are going to be reasonable and not ask for advice on every single issue on the agenda. And that's not been your experience, I don't think. Other municipalities are saying, okay, we're going to have a budget of $10,000 for advice for council for a year. With respect to that idea, how much does advice cost?
It varies.
Yeah.
So I would say that so far, and again, a lot of these aren't simple questions that we've been answering. The least expensive is probably around $500 or $600, and the most expensive is around $7,000. So it's not going to be inexpensive.
That's just advice.
That's
Just
advice.
Yeah.
So, and
Excuse me, but in a way, if somebody wants to make a complaint or it's a price down there, maybe it's cost too much, I'm not gonna do it.
It's not for complaint, this is to get your advice.
To advice, and then,
Yeah.
the advice.
so the advice is to councillors, not to members of the public. So members of the public aren't going to be running up your bill.
Exactly.
They're trying
They're
sometimes, I
trying.
think.
They're trying. And
But
that's a really good point, actually. So I will not give advice to one counselor about some other counselor's possible conflict. I've had that request. Or legal opinions is something else we won't be giving out to counselors about somebody else's potential conflict. It's about your conflict, and that's the easiest way I can put it. I can't.
well, I think that's precisely what the Act says.
It does.
So the Integrity Commissioner can advise members with respect to their obligations under the Code of Conduct and Municipal Conflict of Interest Act, so not other people's obligations. It's in writing, and I mean sometimes it does become a legal issue. So the Integrity Commissioner goes to legal counsel for the municipality to get advice about what the legal aspect of the issue is. And the one that was $7,000 was largely a legal opinion.
I also knew
A big
that,
legal opinion.
and I also knew that was, yeah. I also knew that one was going to be one that some ratepayer was going to make a complaint about, and I've had 4 about that one. So my investigation is there's no conflict. and I write a report to council saying, I got 4 complaints, there is no conflict. And that investment saved a big lengthy investigation and potentially a member of council from, or having to take a member of council to court, so it's.
Advice is cheaper than enforcement.
Better 7,000 than 700,000.
That's right. So we've talked about no limit, a global budget, and then some councils have said that each individual councillor gets a budget of $2,500 or something like that, and then after that they can pay for them for their own advice. We'll see how it works out. So far, people don't seem to be abusing it. I'm happy about that. But that is for council to consider about how they want to control that expenditure. Now,
I'm gonna correct that, Bob.
Go ahead.
There has been a situation where it is being abused, but it goes back to the fact that there's this fractured council and it's a bunch of fighting. So at the end of the day, this is gonna cost this municipality a lot of money to get resolved. And so if I can give council any advice, if you don't wanna spend money on the integrity commissioner, get advice up front and be nice to each other.
pretend your mother is one.
Even, I mean, there's nothing that says you have to like each other. You have to respect the position.
Yep.
That's it.
Disclosure.
The powers of the integrity commissioner have actually increased. They can actually hold a public inquiry under section 33 and 34 of the Public Inquiries Act. So if they're doing their investigation and people are not participating, they could say, fine, we're going to have a trial. The integrity commissioner is going to be the judge. They're going to subpoena people to give evidence under oath and be able to produce documents. So it's important to avoid that situation when the integrity commissioner is doing an investigation to be cooperative. Under the Act, they're entitled to have free access to all books, accounts, financial records, electronic data, reports, and all other papers and things belonging to the municipality. So they get access to the closed session minutes. They get access to legal counsel's opinions that council has received. They get access to all records in the course of their investigation. It's important to know that, just so that you understand the scope of their investigating authority. So you've got to think about the expenses here. Generally, advice is cheaper than enforcement, and it can have personal impact. And I think I was told I have to stop talking at 8 o'clock, and I think I'm a little early. Unless you have.
Cost you money.
It's going to cost me money. I can keep going. Yeah.
Were you gonna talk a little bit about that?
Didn't I hand those out?
No?
Okay. We have another card for
These are
you.
for, I don't think
We have another card for you. You may already have these.
You can take 5-10 minutes to elaborate on that if you want there.
Okay. I got more time.
so you need, do you have enough, Paul?
Not quite for this
Pay
table.
you overtime?
Hein?
You pay you overtime?
Moi, je fais pas d'overtime, fait que l'autre non.
So this
Moi, je l'ai déjà, c'est bon.
this deals with roles and responsibilities of council and staff. And so this is a tool because we do have some municipalities where council doesn't understand their role. And frankly, when council steps outside of their role as councilors, their legal role, that's when we get into complaints to the integrity commissioner about code of conduct or workplace harassment, because sometimes councilors start to try to manage the operation of the municipality. So this is a good tool for councilors to have in their agenda as well, because we're operating a level of government, and we're called a tertiary or the third level of government. we have to have statutory authority for everything that we do. And under the Municipal Act, it lays out what's council's role and what's staff's role. So council's role is to represent the public and consider the well-being and interests of the municipality. What that means is that you are looking at, and this is true, I guess, of local boards as well. When you're sitting on a governance board like this, you're supposed to be thinking about how are the issues that we're talking about going to affect the entire population. One of the things that I tell new councils to do is put the number of their population, write the actual number on your agenda so that every time you're at a council meeting, particularly a heated one where you've got an upset delegation from a member or two of the public, that you can look at that and say, well, okay, there's 2 or 10 really pissed off people in council, but there's 5,200 people in Hearst. So we got to think about the rest of the story. So that's what that first paragraph means. To develop and evaluate the policies and programs of the municipality. So this means to set your code of conduct and your staff council relations policy. So you're a policy setting body. To determine which services the municipality provides. So you decide, do we have a fire department? Because you don't have to have a fire department. You only have to have fire prevention education. If you do have a fire department, then what are the services we're going to provide? Are they going to provide internal attack or just external? Those are the services that the municipality decides. Are we going to have garbage pickup? Are we going to have it once a week or twice every other week? Then to ensure that administrative policies, practices, and procedures and control policies, practices, and procedures are in place to implement the decisions of council. In other words, when you make a decision at the table and you pass a resolution that says we want to report back on a particular issue 4 council meetings from now, you have a policy in place to say, okay, so the clerk's going to put that on the agenda, going to circulate that in the package so that we know that we're going to get that report 4 meetings from now. To ensure the accountability and transparency of the operations of the municipality, this means that you have a procedural bylaw that says, how do items get on the agenda? How do items get in front of council? How are they debated? How do you bring a motion? How does the debate go around the table? How many times does it go around the table? Those are the things about ensuring accountability and transparency. You also have to have an accountability and transparency policy. And I've yet to meet a councillor that can tell me what their accountability and transparency policy says. But what it says is we're accountable and transparent by having the following bylaws, a procedural bylaw, code of conduct, things like that. To maintain the financial integrity of the municipality, so that means doing your annual budget. And then carry out the duties of council under this or any other act. So that's council's role. It's important to understand that council's role is at the council table as a whole. We don't have partisan politics, so we don't have liberals versus conservatives in municipal government. And the way that this system is supposed to work is we have an issue that comes to the table, we debate it, goes around according to the procedural bylaw, it gets voted on, then that's the decision of council, that all of council is responsible to then move forward. So those are the roles of council. It's contrasted with staff's role. So staff is required to implement council's decisions and establish administrative practices and procedures to carry out council's decisions. Note that that says council's decisions, not councilors' decisions. So a single councilor doesn't have the authority to direct staff. The direction from staff has to come from the council table at an open council meeting. Paragraph B is one of the most important responsibilities, and that is to undertake research and provide advice to council on the policies and programs of the municipality. So particularly senior staff are charged to provide council with advice, provide staff reports about issues that you're interested in. And then you take that advice and you consider the advice, and you also consider your political information, what you've heard from the provincial government, all that stuff, and then you guys make a decision. So advice from staff is to be professional and thorough, and you should treat it with respect, but it doesn't control council. So if staff says, you know, there's 3 options, we think you should take option 1, council might say, appreciate that, we're going to take option 2. So staff doesn't control council. The other thing that staff does is they operate the municipality. So they carry out council's decisions. So in other words, council makes a decision. Council actually has only one employee, and that's the CAO.
Mhm.
Council gives their direction to the CAO, and then the CAO is responsible to disseminate that decision to council and make sure that his team does what you want. He's responsible to you for every action of every municipal employee. So as his employer, what you're to do is set out first the expectations and deliverables of the CAO. And then once that's done, do performance reviews of the CAO to make sure that the team is working as you want it to. The reason that this is important is on the back. And that is section 448 of the Municipal Act. I talked about it briefly, but this is your get out of jail free card. So this is actually one of the most important liability sections of any act in Ontario, because most of the time legislation would say you're not liable for damages if you're acting as a councillor, as an example. This goes way beyond that, and it says no proceeding for damages or otherwise shall be commenced against a member of council. So people aren't even allowed to sue you. There are a couple of weasel words in there. The act that they're complaining of has to be done in good faith. So you can't be taking a bag of money, or you can't be breaching the Municipal Conflict of Interest Act. And in the performance or intended performance of a duty or authority under the Act. So in other words, you're acting within your role. So if you're acting within your role as council, being the governance level, the policy setting branch, people can't start a lawsuit against you. And I've used this to defend mayors. I acted for Elliott Lake during the inquiry when the mall came down. And after the inquiry, there was a class action suit that was started. It was against the mall owner and the engineers and the architects and the municipality, and 2 mayors were named personally. And I was able to use section 448 to have the action against them dismissed, because the allegations were that we're only in their role as mayor. So this is extremely powerful, but it's also kind of easy to throw away if you step outside your role. So I used this with a councillor and a CAO, and the way that it worked sort of shows you how or why we designed the card. So the councillor came to the CAO and said, I want to see Mr. Smith's overtime sheet. And the CAO didn't say, no, you can't do that, which is kind of the truth, but was smart enough to say, let's call Paul and figure out what we should do here. So I said to the councillor was on the phone with me, I said to the councillor, so why do you want to see Mr. Smith's overtime sheet? And the councillor said, well, because I think we're paying him too much overtime, obviously. So I said, well, okay, do you think you're paying just him too much overtime? Or are you paying his department too much overtime? And the councillor said, well, really, I'm concerned that we're paying the department too much overtime. So I said to the councillor, okay, well, do you have an overtime policy, and how are you paying compared to the overtime policy? There's a little bit of silence on the other end of the line, and the CAO said, yes, we do have an overtime policy. And I said, okay, well, you might want to look at the overtime policy and get a report from staff on whether you're complying with the overtime policy. And then I said, are you concerned about the department? Is your overtime exceeding the budget? Councillor said, well, yeah, I'd like to know if it's exceeding the budget. And so we ended up with the councillor saying, what I'm going to do is I'm going to have a motion on the agenda for the next council meeting to ask for a staff report on overtime, where we are with respect to the budget and where we are with respect to the overtime policy, and whether we need to update the overtime policy. So what we did in that situation is we took the councillor who had an issue that was valid for council to consider, took it from an operations question where the counselor wanted to look at HR issue and personnel files that the council really should be looking at, and turned it into a policy issue that the council absolutely should be looking at. So that's how this card is designed to protect you. So whenever you're thinking about an issue, especially if it's gray, or if Yves is saying, I think that's operational, I think that's not really council's responsibility, think about how we can reframe it so that it is a policy issue for council to consider. So that's what this is for, because if you do that, then your get out of jail free card is all you get. And the flip side of that, I've had 3 different CAOs call me and say, Paul, Councillor so-and-so has just taken off in the grader. So the problem with that is you don't see and run the grader on the council roll. And what happens there is you're not certified to be trained, so you're breaching the Occupational Health and Safety Act. Your municipal insurance isn't going to cover you. If you wipe out a pedestrian or something like that, your personal insurance probably isn't going to cover you. So you're running the risk that your own assets are on the line when you drive the grader. So driving the grader is an extreme example, but it means like picking up a shovel, council actually doing staff's work is where you can accidentally get outside of this protection. So that's why we have this card. The Connie story. Connie was a counselor, and she was a business. She worked for the school board. Oh, she worked for a school board, but so she had a supervisory background. And what she would do is she would go to various staff members. This was before there was such thing as a staff council relations policy, and ask questions of the staff member and then tell the staff member, you know, I think you should do your job in this particular way. She did seem to have the best interests of the municipality at heart. She thought she was helping. There was a complaint to the Integrity Commissioner and the Code of Conduct. And it wasn't Peggy.
Sure.
And the Integrity Commissioner investigated it and found that she was breaching the Code of Conduct because she was going around and directing individual staff members, which is outside of their role. What she said is that they like it when I do that, and they find my comments very helpful. And staff may very well have said stuff like that to her, because one of the realities is that staff, probably more so junior staff than senior staff, don't want to say no to a counselor. They don't want to say, no, I don't want to go and fix this culvert because I'm going to fix the bridge. And they're more likely to go along with what you tell them. But by being cooperative, they're actually putting you at risk of breaching your role. So Connie thought that she was doing the right thing, certainly said that she was being helpful, ended up getting kicked off the library board as a result of the Integrity Commission's report, got suspended. Oh, she got removed from all committees. She got prohibited from talking to staff except for the CAO, and it had to be by email. Her pay was suspended for 3 months, and at the end of the day, she resigned. So, the problem, the sad thing about it was the Integrity Commissioner in that case was actually a lawyer from, doesn't matter where, Southern Ontario. And I think that investigation was about $63,000. So it was a nightmare because she was going around to all kinds of staff people. So the investigation was huge because the investigator had to probably meet with 30 different people.
And that's the beauty of having an Integrity Commissioner protocol that says you have preliminary review. Because if you look at an investigation like that, and if you have experience in the municipal sector, there's a good chance you could say that it's a breach of the role and responsibility of council to do that. And you could then look at opportunities to try and help that councillor maneuver properly in their role, rather than go through a big, long investigation to slap somebody on the hand. Providing that the councillor is operating from a place where they are doing it in the best interest of the municipality. Some are not. We have an experience of a couple of members of council who should actually have decided to apply for the CAO's job instead of being on council.
Refused because they
That's-
were
that's-
overqualified.
Pardon?
They were overqualified.
Well, this one member of council, he had been a mayor before, then was off for a number of terms. There was a vacancy, so he was the next one in line, and council decided to go with that method of filling the position. And he acted like he was the CAO, performance managing staff for months and months and months, and the workplace harassment investigations that came out of that were significant. So like, council has a very responsible position, and it's important that you understand your role, your procedure bylaw, and when you don't know, ask for help. You have a team of professionals working within your municipal office. You have other resources that are available to you. Make use of them.
Thank you.
You were looking for something.
I was looking for another slide and it
With
wasn't.
that little triangle?
Yeah,
Oh,
Wouldn't
There
it
it
cut-
is.
wouldn't it cut your payment?
there it is.
so this is a diagram that some people have said is helpful to understand the municipal organization. So as a governance body, council sits at the top of the organization and they make decisions about policy. I've told you already that you really have one employee, and that's the CAO. So you guys sit around the table and you make decisions and you tell this guy here what you want him to do, and then he's responsible to do it. And he may tell you that he needs a bigger budget or he needs more people, but he's responsible for that process. So you tell him, then he tells the people down here that need to know what is done. So the information and decisions flow from up here, down here, and then get disseminated by this person down this way. So you want to avoid situations where information from here is coming down here. And I told you about the case near Sarnia where the councillor directed the road crew. So that's exactly what happened in Sarnia. One councillor went down here and told the road crew what to be done, and people ended up dying. That's a sad example, but it shows how it's very important when council sets a decision that it go through somebody who's responsible to know the whole operation. Because the CAO or even the director of public works would have known, yeah, the guy's culvert might be important to him, but we're better off to solve the safety problem.
Hey, Paul.
Yeah.
I understand what you're saying about that, but I come to the office and I know CEO is busy, the door is closed, and I want to have an answer and information. I'm not allowed to go and talk to Janine.
So this is where it's
Janine, you
important.
want to talk to me, it's okay.
Yeah. This is where it's important for council to decide what their staff council relations policy is going to say. Because it's important that you're able to, we've got to be careful with the example that you just said. Because you as the mayor are, with respect, only a councillor.
Yeah.
And so you as the mayor don't really have any authority to direct staff, whether it's Janine or anybody, to do something that council hasn't authorized them to do, right?
Mm-hmm.
So now, your staff council relations policy should lay out who and how councillors can ask questions of staff. And we've had some interesting examples of that. And some municipalities decide that you must go to the CAO, and then with the CAO, go to whoever else the CAO says that you need to talk to get the information. The other thing that the staff council relations policy does is it ensures that if you have a question or any councillor has a question, when the CAO knows about it, he can ensure that all of the counselors get the same information. So if you, for instance, had read a staff report and you have a question about something from the treasurer, and you bring that to Eve, and he takes you to the treasurer, and they both say, wow, that's a really good question, and we need to get more information for you. Then he can task people to get the information, and that gets disseminated to all of council.
Why I'm asking that, I think all council and even myself, we want to do the right thing, and most of the time, Janine's got all the information, and she's going to tell us, well, you're not allowed to do this, you shouldn't do this instead. And
I guess your question basically is, you wouldn't be allowed to give directions, let's say, to Nathalie at the reception,
No,
go do that.
no.
That's what he means.
Yeah,
It
well,
has to
that's-
come to the administrator, but it doesn't prevent you from talking to us, asking questions on what's going on, what's this meeting. I guess that there's a
well,
difference
that's what I find
there.
out.
And so this is for council to decide in your staff council relations
Okay.
policy. Some municipalities say you must go to the CAO and the CAO only.
Okay.
Some, and I'm not saying that's the only way to do it. Some say you can go to the CAO or you can go to department heads or the clerk. Or
Let's
the,
say
or
even
the treasurer.
finance, if I got a counselor on finance, and he wants to get information on finance, you're gonna go see a treasurer, she or he's not allowed to go over there, it's got to talk to the CEO first.
So we're going to have to make sure that, like, it sounds like you've got committees that deal with certain issues.
We're on working groups.
Okay, so what you're calling working groups are probably committees.
Council
Yeah,
committees,
that's basically what
Yeah,
it is.
because I expect that the working groups explore issues in depth that council doesn't really want to
That's
get to. But then the working group, I'll call it a committee, gives a recommendation to council, and
To
council
council,
makes the
yeah.
decision. So the working group
Yeah.
doesn't make any decisions, right?
No.
Good. So that's a bit different, because that's not
Not
council
directing staff.
that's going to the staff. That's a committee that presumably has terms of reference about what their role is and a mandate, like a length of time.
It's
that
still
the
a
committee is
counselor going to the finance people.
It is, as the committee member, not as a
As a
council.
counselor.
Yeah, it's not all the counselors should go over there, it's the chair of the
That's right.
working group.
So if you're not on the committee, you don't go and start meddling in
Yeah,
what that
that's what I'm
committee
saying.
is doing.
I just want to find out how we doing it.
Yeah.
If we're doing it the right way.
So you're going
Because
to.
like Janine, she knows, and she learned just like us tonight there, but if I want to have good information, I go see her, say, Janine,
Yeah.
do I allowed to do this?
Yeah.
And do we have a bylaw for that?
Yeah, and you're getting the staff council relations
Because if we
policy.
knock on Eve doors every day, he won't be able to do it for.
Well, and that's something that you have to watch out for. We've seen counselors get into trouble. There was a case in Brighton, and I think Fred Dean was actually the integrity commissioner. And what happened is a new counselor got on council and would inundate staff with email questions, trying to find information that the counselor was interested in that may or may not relate to stuff that was on the agenda. And the staff was then not able to do their job because they were spending all day answering the questions. Yeah, there were 300 plus emails this guy was sending out a day.
My God.
And so what Fred Dean said as the integrity commissioner was that was actually directing staff's work. And when you direct staff's work, you're actually spending money in the municipality, right? Because they're paid to do their job. And if you take their focus from that, then you're paying them to do whatever it was that you asked them to do. So you're in effect making a decision of council without a council. Is how that's looked at. So council needs to decide when you pass your staff council relations policy about who you talk to and how you get to them. And it's important to understand that that's not set up. It's not done in order to frustrate council's ability to get information. To the contrary, it's designed so that you get all of the proper information, because Eves knows, or is supposed to know, what all of his departments are doing. And I don't know if I told you the story about the fire department, but I have a municipality that was trying to build a fire hall. Did I tell you the story?
Yeah.
So if you get information from one department, it doesn't contemplate the roles of the other departments that might affect the same issue. So that's why it's important to have a protocol that you understand, and then to ensure that the CAO, even if you go and talk to Janine or you talk to your treasurer or something, it's good to let the CAO know what you were talking about, because if you have a question and you got a bunch of information about an issue that's on the agenda, the CAO is going to want to say, oh, I better get that same information out to all the members of council, because councilors get frustrated with each other when one person knows a whole bunch of information and the others are excluded. And that's what the staff council relations policy is designed to do. And I talked to you, I guess, already a little bit about the trap that sometimes lower level staff do, where they try to talk to one of their friends on council about an issue, and that lures you out of your role as council, and it gets you potentially outside of the 448 protection. So that's, you don't want to let them do that to you. I want to talk a little bit, if I can have 10 more minutes. Can I have 10 more minutes?
Not really.
No?
5 at the most.
Okay. Okay, I'll make it super quick. I'm going to give you 2 tools that councils have been very successful with. One is, you know what a strategic plan is, and I understand this is something that this council is going to look at, and that's great. It's an opportunity to look long term. But something that I would urge you to think about is a council term action plan. What this is you get together as council and you say, in this 4-year term, we're going to do the following 3 or 4 things. You basically make a promise to your ratepayers, we're going to achieve these 3 or 4 goals. It really helps you as council stay focused on what's important to you, because inevitably what's going to happen at almost every council meeting is somebody's going to come from the periphery with an idea, and if you don't have a plan of where you collectively want to go, it can be tempting to go off in all different directions, and then you don't get anything done. So this council term action plan, now is the time to do it, where you sit down and you say, we're going to do these 3 things come hell or high water during this 4-year term.
Is that an open meeting, or you can do that in a private session?
It would be an open meeting.
Open meeting.
Yeah.
And you discuss.
And you discuss what your priorities are. And right now, right after the election, you've got the best knowledge of what your ratepayers want, because you've been out knocking on doors, talking to people, having coffee with people, so you know what you were elected for and what you want to achieve. I urge you to set out only 3 or 4 things for this plan, because it's important that you show a direction that you're going to go, but also set something up that you can actually achieve. The experienced counselors around the table are going to tell you that 4 years is going to go by at one time. And I don't want you to set yourself up to fail by saying, okay, we're going to do these 25 things, and you get through the first 2, and at the election, people are going to be saying, what the heck are you guys doing? So you set it up so that it's achievable, it's concrete, we are going to do these 3 or 4 things, and then when issues come to the table or staff reports come to the table, staff can say, this moves your council term plan forward, or this takes you way off track. And in which case you may want to say, that's a great project, we're going to consider that next term. So the council term action plan is one thing I would strongly recommend. And the other thing that I would strongly recommend is this concept of an annual calendar. The annual calendar is designed to be a staff commitment calendar, so that you can look on the wall in your council meetings and say, okay, in the month of June, the following things are being done by staff. So that if you're coming forward with a request for a staff report, you can look on the wall and say, oof, they're really tied up for these next 2 weeks, so I'm not even going to ask for my staff report before 4 weeks. Or you might say, as a council, wow, staff's really tied up for the next 4 weeks, but this that we need done is way more important than the project they're working on. So we're gonna move this, which is gonna have a ripple effect on the rest of the calendar. But if you can visually see it, it's a lot easier for you to be reasonable in what your request is for a staff report, and you can set a reasonable date for return of that project. I have had a number of counselors who have come to me and said, you know, I'm really frustrated with staff because we've given them these decisions, we've passed resolutions at the table, and they're not doing it. And I often say, okay, well, show me the resolution. And I look at the resolution, and without fail, if I've had that complaint, the resolution doesn't have a return date. It says staff should do a report on recycling. Well, okay, they're going to get to it when they think it's appropriate if you as council haven't prioritized it. You as council have the authority to say, and this will be done in 2 weeks. It's nice if you at the table have a discussion about what's going on in the 2 weeks, and that's why the calendar is so important. So in your resolutions, I would suggest considering this annual calendar. It's perfectly fine to make this annual calendar public as well, because one of the things that some members of the public think is that municipal staff sit around collecting a paycheck and not doing anything. And if they actually saw what these people do on a day-to-day basis or week-to-week basis, they would be amazed at the value that they're getting for what they pay. So the annual calendar is a really good tool for planning, for communication between you and staff, and also for ratepayers to understand that there is a lot going on in running a municipality. So those are the two tools that I wanted to cover.
And I think one of the other things I'd like to suggest you put onto your annual calendar is those bylaws or policies that council is going to review. What often happens in the municipal environment is council passes policies, and then 20 years later they get challenged on a policy and say, oh, well, we haven't been doing that. In fact, one of the stories Paul tells is that the clerk says, well, we don't follow that. I tell council we're not following that because it's illegal. Well, if it's illegal, change your policy. And a lot of policies have not been updated since 2001 when the Act changed. We have a library that we're working with council on their library issue right now, and the library is back even before they were a municipality. So
They were a settlement area. This is going back to the 50s.
So, you know, the problem is when you have policies, they need to be current. You're adopting policies for staff to use as tools on how they do their job, and they need to be looked at on a reoccurring basis. And so part of your calendar, and maybe part of your council term action plan, is you're going to pick a certain number of those policies and make sure they're all up to date. And so that's my soapbox moment.
Okay, I could talk all night, and happy to answer any questions. But thanks very much. Keep going.
He wants to go to the bar, the companion.
Okay.
I got $80. 20 beers.
Thanks very much.
Pocket change.
Pocket change.
I see, that's all I have for the whole